Liquidator and the Primeo Fund.
Yes. Mr. Tree.
My Lords, on this appeal from a judgment of the Cayman Islands appeal dated 27th of February 2018, I appear with my learned friend Max Slot and my learned friend Tom Tar.
Yes, thank
Here
you.
for Primeo. Together with Mr. Slot, I appear for the additional liquidator, Mr. Pearson. My Lords, before I get into our submissions, there are possibly one or two matters of housekeeping in relation to which the Court wished for an explanation and various developments in relation to paper.
Yes.
May we apologise for the state of the bundles that were delivered to the Court. They were in a form which I think everybody found impossible to use. So there was a mistake in the form of the bundles, but the mistake is against the background where this is a case where the timetable for preparation was suspended for a period while the additional liquidator was seeing if the case
Was that suspension by operation of the Privy Council rules?
I think the suspension, as I understand it, was one that the appellant's agents in London were informed by the registry that the timetable would be suspended, pending the decision. Not entirely certain whether this was by operation of the rules, but certainly the understanding was given to the agents in London. And then on the 3rd of October, so the suspension was on the 16th of September. On the 3rd of October, the parties were informed that the application for the and at that point, the timetable for the written cases was slightly late. Ours went in on the 8th of October. The respondent got on the 14 days. In fact, got it in slightly earlier. The difficulty with that was it was impossible to complete the bundle with its pagination because the written cases had to be slotted in. So against that slightly compressed timetable, mistakes regrettably were made, and the bundles came to your lordships in a form where your lordships rightly rejected them. They then appeared in a form which we hope has been useful to your lordships and your ladyships. They came in spiral bound. There were two mistakes made. One was the form of the bundles, and the other was not dividing up the bundles. And the difficulty was once that mistake had been made, it had all to be done again because tabs...
Well, I don't think we need to spend much time on this.
Well,
I do have to say that the registry is hard-pressed
Yes.
at the best of times. And there's been a lot of energy and time expended contacting your solicitors,
Yes.
and trying to encourage them to comply with the various directions that have been given. So we'll say nothing more about it now, but let this be a precedent and a learning experience for all of us.
Well, my ladies and lords, I'm sure that message is heard and taken in. And again, all I can do is express our regret that happened. Perhaps inevitably, then various documents have come into your lordship slightly late. On Friday, we submitted in soft copy our written case with up-to-date bundle references, which I hope your lordships and your ladyships have. That was available, I think, lodged in hard copy on the Monday.
Yes.
That being said, I hope there are no more glitches with the bundles. If there are, I'll deal with them at the appropriate moment, but I'll keep my fingers crossed.
Yes.
My ladies and my lords, as I said, this is an appeal from a judgment of the Cayman Island Court of Appeal. Subject to your ladyships and your lordships, we've agreed to allocate our time as follows. I will go on until 12:30.
But don't feel obliged to go on until...
I won't feel obliged. Clearly, if I run out of things to say, I'll stop rather than filling up the time. My learned friend has an allocation of 2 hours, and then I have an allocation of half an hour at the end for reply.
Yes.
My lords, my ladies, this is a fairly narrow, short issue. Essentially, it's the issue is the correct interpretation of section 112.2 of the Cayman Islands Companies Law. And just for the reference, although I'll look at it in more detail in a moment, the section itself can be found at volume 9, tab 6, at page 2361. We're dealing with 112.2, which is 4 lines of text.
Did you say 2261?
2361.
2361.
Oh, I misheard you. Thank you. Yeah.
4 lines of text. And the issue is, what is the scope of the power to rectify, which is contained in the 3rd line, 112.2. My ladies and my lords, before going to those words, what I propose to do, is subject to the court, is to say a little bit about the factual background of the Madoff fraud, salient facts relating to this liquidation as they appear from the statement of agreed facts, and just a little bit about the position of Primeo as a member of the of Herald vis-à-vis the other members. And then our submissions will then consider the correct interpretation of 112.2, i.e. does the additional liquidator have the power he is proposing to exercise under that section? If he does, is he right to exercise that power in this case? And if he's right to exercise the power, is his method of rectification within the scope of 112.2? And lastly, does the power in 112.2 extend to rectification of the register to restate the shares acquired by Primeo on what's called the in specie subscription in 2007? If the court would be good enough to take up Bundle 8 and the statement of agreed facts, which starts at tab 8 at page 2224, and if you'd be good enough to turn to page 2238, just so we get some of the facts. On the 23rd of July, the additional liquidator was appointed. The order itself is at page 10 of the bundle, but I think we get enough from paragraph 37 of the statement of agreed facts at page 2238. And he was specifically required to settle a list of contributors and to consider related issues, and in particular, whether the company's register of members should be restated pursuant to section 112.2, and whether the petitioner's shareholding, that's Primeo, who petitioned for the winding up of Herald, should be adjusted on the ground that the consideration for the issue of its shares was the transfer to the company of the portfolio of cash and securities, and or cash held by the petitioner in its account with what we call BLIMIS, which is Bernard L. Madoff Investment Securities, LLC, the amount or value of which had been fraudulently overstated. At page 2224 of the bundle, which is still within the statement of agreed facts, the court will see that Mr. Pearson is a representative and Primeo is a representative, and they represent the parties who are affected by the issues on this appeal. The purpose for which he was appointed was then framed as 2 rectification issues, which we can see at 2224 in paragraph 7 of the statement of facts. And the issues which are live on this appeal, if we look at page 2224, are the issues which are set out in 6b. That's the one which relates to 112, section 112, and the issue at paragraph 7, which is the in specie subscription, in relation to which the issue is whether 112.2 gives the additional liquidator the power of rectification for which he is advocating. So at the beginning of the liquidation and on the appointment of the additional liquidator, there was a general mandate to consider rectifying the register in the context that Herald was a fund which issued shares in return for subscriptions. All of the funds raised by Herald were then placed by Herald with BLIMIS, save for relatively insignificant sums of cash. The value of the Herald fund at any time reflected the value, or the supposed value, of its investments in its account with BLIMIS. And the subscription redemption price at each valuation date for Herald was always based on Herald's NAV from time to time, save at the outset when the shares were deemed to be worth $1,000. Each share was subscribed for $1,000. So the NAV was at all times based on the information that Herald got from Blimis, and the NAV was based on what were thought to be substantial holdings of securities and assets set out in Blimis statements, which went into great detail about the acquisition and disposal of securities by Madoff. And that's set out at paragraph 24 of the Statement of Agreed Facts at 2236. As we all now know and knew from December 2008, Blimis was a fraud engineered by Bernie Madoff. And there is a good description of the fraud, which I think can compress what I can say, in the US authority, Bernard L. Madoff Investment Securities, which is at page 2699.
Sorry, give me that number again, please.
The page number is 2699.
Oh, no, thank you.
And that's bundle 10 of the authorities at tab 36. And if I might take the court to page 2699, which sets out the background. Under the heading background, 5 lines down, when customers invested with Bernard L. Madoff Investment Securities, they relinquished all investment authority to Madoff. Madoff collected funds from investors, claiming to invest those funds pursuant to what he called or styled as a split-strike conversion strategy for producing consistently high rates of return on investments. The split-strike conversion strategy supposedly involved buying a basket of stocks listed on the Standard & Poor's 100 index and hedging through the use of options. However, Madoff never invested those funds. Instead, he generated fictitious paper account statements and trading monthly account statement listed securities transactions purportedly executed during the reporting period and purported individual holdings in various S&P 100 index stocks at the end of the reporting period. The statement did not reflect any actual trading or holding of securities by Madoff. In fact, the trustee's investigation revealed many occurrences where purported trades were outside the exchange's price range for the trade date. And then if I could ask your lordships to turn, and your ladyships to turn to page 2700, first paragraph. As is true of all Ponzi schemes, Madoff used the investments of new and existing customers to fund withdrawals of principal and supposed profit made by other customers. Madoff didn't actually execute trades with investor funds, so these funds were never exposed to the uncertainties or fluctuations of the securities market. Fictional customer statements were generated based on after-the-fact stock trades, using already published trading data to pick advantageous historical prices. The customer statements documented an astonishing pattern of continuously profitable trades, approximating the profits Madoff had promised his customers, but reflected trades that had never occurred. Although Madoff's scheme was engineered so that customers always appeared to earn positive annual returns, the dreamt-up rates of return Madoff assigned to different customers' accounts varied significantly and arbitrarily. Thus, the customer statements reflected unvarying investor success, but the only accurate entries reflected the customer's cash deposits and withdrawals. Then if I could ask the court to turn to page 2701 in the middle of the page, that's a paragraph starting, in satisfying customer claims in this case, Mr. Pickard, as the SIPA trustee, determined that the claimants are customers with claims for securities within the meaning of SIPA. The trustee further concluded that each customer's net equity should be calculated by the net investment method, crediting the amount of cash deposited by the customer into his or her Blimis account, less any amounts withdrawn from it. The use of the net investment method limits the class of customers who have allowable claims against the customer property fund to those customers who deposited more cash into their investment accounts than they withdrew, because only those customers have positive net equity. And then if I can just drop down to the last 4 lines of page 2701, the bankruptcy court emphasised that the Blemis books and records exposed a Ponzi scheme where no securities were ever ordered, paid for or acquired, and concluded the trustee could not discharge claims upon the false premise that customer services positions are what the account statements purport them to be. The net investment method, unlike the last statement method, allowed Mr. Pickard to, in the bankruptcies court, unwind rather than legitimise the fraudulent scheme.
Yes.
And just the last section, if I may, just at bottom of page 2702, last line, as the bankruptcy court observed, any dollar paid to reimburse a fictitious profit is a dollar no longer available to pay claims for money actually invested if the last statement method were adopted. And in the last 3 lines of that paragraph, the statutory definition of net equity does not require the trustee to aggravate the injuries caused by Madoff's fraud. Use of the last statement method in this case would have the absurd effect of treating fictitious and arbitrarily assigned paper profits as real and would give legal effect to Madoff's machinations. My Lords, that encompasses really what Madoff did and what the effect of what Madoff did was. Anybody who invested early would derive greater fictitious profits as their investment grew over time. Any investor who redeemed during the course of Madoff's trading life before a bankruptcy would redeem at prices reflected a fictitious profit. As at the last valuation date before Mr. Madoff's confession, the total reported value of Herald as a fund, so the value of Herald's account with Blemis, was $1.874 billion, which included about $40 million of cash, and those figures are at page 2237 in the Statement of Agreed Facts. Herald filed its customer claim in the liquidation of Blemis in the US, and its claim was allowed in the sum of $1.172 billion, and that figure is at page 2239. And that was on the basis of its net equity, its total cash invested less total payments to it from Blemis. And that amount included the value of the part of the Herald Fund that had once belonged to Primeo before the in-specie subscription in 2007. And the in-specie subscription valued the Blemis account at $3 million. The SIPA trustee, Mr. Pickard, allowed that claim on a net equity basis at a value of $149 million. As the court will have derived from the account until now, Primeo had its own account with Blemis and had been an investor in Blemis for some considerable period of time, as well as holding shares in Herald and other funds. And it transferred its account with Blemis in 2007, which gives rise to the in-specie subscription point, and the facts in relation to that are at 2233 of the bundle. The effect of the in-specie subscription was that on the basis of the $463 million value of the Blemis account, Primeo received 371,000 shares, and that's at paragraph 21.1 of the Statement of Facts. My Lords, in an earlier judgment given in this case by Justice Jones, which is at page 1188 at paragraph 13, but I'm not sure we need to look at it at the moment, Mr. Justice Jones pointed out that both sides of the in-specie transaction were affected by the same fraud. The securities supposedly held by Blemis for the accounts of both Primeo and Herald never in fact existed. It follows that both the recorded value of Primeo's in-specie subscription and the amount of Herald's reported NAV were overstated by reason of the same fraud. Ponzi schemes always produce winners and losers, and in the context of this liquidation, Primeo, we would submit, should be seen as an investor who has done very well. Shortly before Herald's final valuation date, Primeo redeemed and received payment to the extent of $172 million in respect of shares which were redeemed 10 days before Herald suspended the calculation of its NAV on the revelation and disclosure of the Madoff fraud. And it's common ground that those shares were redeemed at a NAV that was based on the supposed value of non-existent assets. If the Court of Appeal in the Cayman Islands is right about the in-specie subscription, then Primeo will benefit from the valuation of their account with Blimis, translated into the value of the shares it obtained in Herald. And so effectively, its return will be expressed on the basis of a value of 463 million rather than the 150 million, which was calculated on a net investment basis as between Herald and the trustee in New York. Because they will receive payment in respect of fraudulently overstated NAVs, and because there is a fixed pool of recoveries, Primeo will receive payments at the expense of other members of Herald who invested with cash in the normal way. And as was observed by the judge in the US authority which we just looked at, every dollar paid to reimburse a fictitious profit is a dollar less to pay claims for money actually invested. And again, in the previous litigation in this matter, in Mr. Justice Jones's 2016 judgment, he observed at page 1190, paragraph 17, Primeo will be a major beneficiary, if not the major beneficiary, of Madoff's fraud at the expense of Herald's other shareholders who subscribed cash for their shares. As is obvious, to the extent that Primeo does well, and to the extent that it recovers on the basis of fictitious profits, other members in the solvent liquidation of Herald do badly. And the possibility that this might be the case was clearly what drove the court in Cayman on the making of the winding up order to task the additional liquidator with reviewing the situation pursuant to Section 112 of the Companies Law. Now Primeo's case is nothing can be done about this. And if one looks at paragraphs 51 to 52 of their written case, this is at page 2310, that's at Bundle 8, tab 11.
Page again.
2310, my lord.
Which paragraph do you want to?
I was going to ask your lordship to look at paragraph 51,
Yes.
which follows, and your lordships would have seen this already, your lordship would have seen this already, follows a review of previous authorities, Fairfield Sentry, and an earlier decision in relation to the additional liquidator relating to the redemptions that Primeo made very shortly before the Herald's NAV was suspended. And the statement which is made there is that those cases and the law in general clearly demonstrate that contrary to the case being advanced by the appellant, there is no incongruity or even oddity in a shareholder being able to recover sums from the liquidation of an investment fund which represent an element of fictitious or fraudulently inflated profit, if that's a consequence of the shareholder's legal rights under the company's legislation and articles. Now, my lords and my ladies, those cases on which that statement is based are in fact not cases where shareholders were recovering in a solvent liquidation at falsely or fictitiously inflated values. They were both cases where in fact the issue was between ex-members who had redeemed, who had become creditors. So Fairfield Sentry was essentially a clawback claim against members who had left the fund, and this committee found that as redeemers, they had come out of the fund, they had a contractual debt owed to them in the sum of a fictitious NAV. The NAVs were binding, and those redeemers were entitled to be paid in full, and there was no basis for recovery by the fund. In the Pearson and Primeo case, which is also referred to, that was a case of December redeemers who had redeemed but not been paid just before Herald suspended its NAV. And again, on that basis, this committee held that the line had to be drawn at the point where they had redeemed, become creditors, and ceased to be shareholders. And so effectively, it was not a competition intra-shareholder. It was a competition between ex-members who had derived contractual rights in the process of their redemption and leaving the fund. So, my lords, those cases don't, in our respectful submission, justify a line of persuasive authority that shareholders, there's nothing incongruous in shareholders being able to recover in the liquidation of an investment fund based on fictitious or fraudulently inflated profit. And particularly, we say in this case, where the competition here is not between creditors and ex-members and people who remain in the fund, it's between all the members at the point where the winding up order has been made. And it's a question of what those members, who are all in the same class, the remaining members in the liquidation, take out of the liquidation. As we submit, Primeo's case, nothing can be done about this. The law is absolutely plain. But as we submit, this case, or the issue at the heart of this case, is different from those other cases, which don't support the statement of paragraph 52. The issue in this case is whether section 112.2 allows the additional liquidator, or empowers the additional liquidator, to seek to rectify the share register in order to ameliorate the effects of a pervasive fraud, so as to adjust the rights of the remaining shareholders as amongst themselves in the circumstances of what was in Herald what's been termed an external fraud. The cases make a distinction between an internal fraud, such as the case of weavering, or an external fraud, such as this case. In this case is an external fraud because there was no fraudulent conduct on the part of the directors or administrators of Herald. Effectively, Herald is a proxy for the fraud being implemented by Mr. Madoff. Mr. Madoff's fraud fed through into Herald, and every value in Herald was the articulation of the fraud of Mr. Madoff. Our case is, quite simply, that the power under 112.2 is one that enables the additional liquidator to ameliorate the position, and that it is to be regretted if Primeo is right and nothing can be done. Because the effect of doing nothing is simply to perpetuate and perfect the Madoff fraud in the distribution of assets out of Herald to its members.
Will I be going to the section now?
Going to the section right now, my lord, yes. Page 2361 in the bundle, that's bundle 9, tab 13, subtab 6. Now, my lords, my ladies, this is a new provision introduced into the Companies Law in 2009. But I should perhaps say just a little bit about how it came to be there and what its antecedents were. Before this revision in 2009, section 112 looked like page 2384 in the bundle, which is at tab 11 in the same bundle we're looking at. And we can see immediately that it covers some of the same ground and is very different in other respects. Just for contrast, 112.1, as it was before the 2009 revisions, deals with the settlement of the list of contributories and says that it is the court that should settle a list of contributories. 112.1 provides in the 2009 revision that it is the liquidator to settle a list of contributories. And the wording in 112.1 before the changes, so that's at page 2384, provided that the court shall settle a list of contributories and may rectify the register of members in all cases where such rectification is required in pursuance of this law, and shall cause the assets of the company to be collected and applied in discharge of its liabilities. When we go to 112.1, what we see is that the obligation of the liquidator to settle a list of contributories, if any, for which purpose he shall have power to adjust the rights of contributors amongst themselves.
It would help me, Mr. Figure, just to
Yes.
set both the old 112 and the new 112 in their context as part of the liquidation structure set out by the Act. You perfectly helpfully
Yes.
just
Well, I'm afraid we've just taken
this provision and that one page.
Yes.
But sometimes it helps just to see it in context.
Well, in the context of the Cayman company's liquidation
Yes.
structure, it's very similar to the structure we have.
Well, it may be, but it's just nice to read it in its context.
I think so far as the sections that we put in the bundle, I'm not sure I'm going to be able to do that.
Okay.
But I can certainly provide.
We can probably get them off the internet.
Well, I'm sorry about that, but what we've done is each tab has a separate.
Yes, I know.
A separate.
Well, it may be that you can provide a note and agreement with.
Of course, we'll do that.
I mean, just for
Yes.
example,
Yes.
are these powers of the court in all liquidations, winding up by the court, under the supervision of the court, voluntary liquidations, solvent liquidations, insolvent liquidations, or are they in any way limited by the nature of the liquidation?
Well, we'll see from 112.2 immediately an important limitation in the nature of liquidation. But my Lord,
Yes, I appreciate that.
as suggested.
But I'm just looking to see what the
Yes.
general ordinary powers of court doesn't tell you very much what situations these powers arise in.
Well, our submission is that these are the 112.1 applies after the court has ordered the winding up of the company.
This we're in the old 112.1.
112.1 and the new 112.1.
Okay.
And they apply to all liquidations made pursuant to a court order. And so they do not distinguish between different kinds of company or different kinds of liquidation. But when we get on to 112.2,
Did it apply to a purely voluntary liquidation?
I'll take instructions on that if I may. These relate to court-supervised liquidations made after.
So either winding up by the court or
Yes.
winding up under the supervision?
Supervision of the court, yes.
We got the contents list. We're missing the cross-headings. I was interested in also section 46.
Oh, section 46 we do have, Mike Miller.
We've got it, I know we've got it, but we
Yes.
haven't got the
Oh, the
cross-heading, which
context.
I think is distribution of capital.
Yes, the context of the bundle we have, obviously, at tabs 1 to 23.
No, it's the contents of the company's law.
No, we don't have the contents of the company's law as a whole, and my lords will provide that with the note. I do apologise, but that would be useful.
Where do we go now?
Where do we go now? Well, then I want to look at 112.2, if I may.
Right.
So 112.2, which we see at page 2361, is entirely different from the 112.2 at page 2384, which moves to another part of the company's law altogether. It's limited in its application to solvent liquidations and further limited by reference to solvent liquidations of a company which has issued redeemable shares at prices based upon its net asset value from time to time. And further, what is new in this section is that it provides for the liquidator to have a power to settle the company's register of members and, if necessary, rectify the company's register of members, thereby adjusting the rights of members amongst themselves.
Nothing to suggest that he is bound by the finality of a certificate, is it?
No. No, it's a power expressed in the most general of terms, but in a limited set of circumstances, which is effectively a fund which has issued shares at a NAV, which is in a solvent liquidation. And we would respectfully submit that that's going to be quite a niche role for the section, because although it's suggested in my learned friend's written case that funds are often go into solvent liquidation, the Weavering case is a good example of a fund that didn't go into solvent liquidation, and the Madoff bankruptcy in New York was not funded by assets within Madoff, but by recoveries from banks and other players at the time of the Madoff fraud.
But Herald is a solvent liquidation.
Herald is a solvent liquidation because it's recovered in the Madoff bankruptcy, which in turn has recovered very substantial sums from clawbacks, monies that were repaid into Madoff, and recoveries from banks. Sorry.
There's an obvious linguistic distinction between 112.1 and 112.2 in the sense that one's about the rights of contributories and the other one's about the rights of members.
Yes.
We often think of contributories and members in sort of rather parallel boxes.
Yes.
Is that in this context because someone who's had redeemable shares at price based on net asset value won't be a contributory in any circumstances?
Well, I think they will be counted as a contributory, but the settlement of the list of contributors is very often focused on questions of paid, fully paid, and partly
Yes,
paid
absolutely.
shares.
I mean, contributory really means it
Yes.
in that context. You've got to see what his liability to contribute.
And the rules provide that if I think we can see that from Order 12, Rule 1, the rules provide that if it's not necessary to do a list of contributors, then the liquidator doesn't have to do one. So the list of contributors, in a sense, is something of possibly something of a hangover from the days of shares which are not fully paid up. For example, Order 12, Rule 1, which deals with the settling of the list of contributors, which is at page 2367, provides that the official liquidator needn't settle any list for the purposes in 11A unless the company was incorporated on the basis that its members' liability is unlimited or is limited by guarantee, or it appears to him that the company has issued partly paid shares. So the list of contributors is an exercise that goes to something which is not in all cases necessary, and where it's not necessary, then the liquidator's task is one that he's relieved from having to do. But where we submit 112.2 moves on is by focusing on the register of members and the rectification of the register of members. And in a very limited category of cases. And what we respectfully submit is that it provides a power in the solvent liquidation of funds for rectification of the members where it's necessary to do so. And in rectifying, the rights of the members amongst themselves can and will be adjusted. And so the rectification and the adjustment of the rights of members are appearing in the same phrase, in a way which, and in a completely new context, which means, in our respectful submission, section has to be read afresh, not using old phrases taken from different contexts in companies law going back to 1862. So in our respectful submission, what the statute is making clear is that the effect of rectification will, if the power is exercised, involve the adjustment of rights of the members as between themselves.
Remind me, did you tell us what happened to the general power to rectify the register under old
Section 46 remains. Section 46.
Section 1121.
Section 1121 that section, the power to rectify, is not reproduced in the company's law. There are two powers to rectify in the company's law. Section 46, which is the usual power of rectification, which we're familiar with from English company law, and 112.2, which provides what we submit as this new power of rectification in the context of solvent liquidations of funds.
But there was always Section 46.
Section 46.
Yeah.
Yes.
What page is that?
Section 46 is at tab 3, page 2353, 2353. Section 46 is a general power of rectification. It's not expressed it's not something that happens on liquidation. It's simply a power of rectification which exists at all times. But it's a power of rectification by the court on application made to it. So the classic case is where somebody has transferred shares and remains on the register, or has acquired shares and hasn't been placed on the register. An application can be made to the court to rectify the register, to either take away or add the name of the relevant party claiming rectification.
But so old 1121, did that add anything in terms of rectification?
Old 1121 has gone in its form that it was.
I know that.
And it's
I'm wondering what the point of it was before 2009?
Well, to the extent that if one is making calls and then changing on a list of contributors, making a call and showing a share is fully paid up, then there may be some rectification. But that's the 112.
Well, Section 46 requires an application to be made.
Yes, and it's done by the court.
Yes, but it's someone who is aggrieved either because he wasn't on the register when he should have been,
Yes.
or he remained on the register and he ought to have his name removed.
Yes.
Whereas 112.1 in its original condition arose where an order for winding up the company made by the court, then the courts have that power. It doesn't require application by an aggrieved individual.
No. What it will do is, to the extent the register shows what has been paid on a share, there will be a rectification of the register to show if a call has been made to change what has been paid in relation to that share. But that's all part of the exercise of identifying the contributors and what their liability to contribute to the assets of the company is. 112.2 in our respectful submission moves right away from that, because it doesn't deal with all companies. It deals with a small category of companies, an important category of companies in Cayman, and it deals only with those companies when they're in liquidation and the liquidation is solvent.
Would you say that Section 46 is just a procedure, a summary procedure where you can get before the court to ask the court to rectify the register because there's some legal ground for doing so outside the Companies Act?
Yes.
But by contrast, is it your submission that Section 112, subsection 2, is a substantive provision which gives the power to amend irrespective of there being legal rights outside?
My lady, we do say that.
So that's why it's a separate section.
That's why it's separate, yes. And my lady, we say it's addressing a particular problem. Section 46 remains there to deal with all sorts of different categories of case that can emerge. Section 112.2 is narrow focus, small scope of application,
It's
funds insolvent
sort of
liquidations.
baby has fallen out with the bathwater on one view, because 112.1 in its old form, I suppose, made it clear that whether or not Section 46 in its own terms would work in a liquidation, I'm minded to think it might not.
Yes.
Nonetheless, it is made to work in a liquidation because Section 112.1, if you like, expressly extends without any limitations as to the type of liquidation or the type of company.
Yes.
To enable rectification to happen during the liquidation process.
Just in case the power doesn't survive the winding up order under 46.
But that's gone in the new 112.1, which says nothing at all about rectification. And all there is in the new 112 about rectification is for a particularly very narrow class of liquidations.
Yes.
But what's happened? Well, why is the previously broad provision for rectification 112.1 gone, unless it's an accident or unless it's intended to be in some way encompassed within 112.2?
Well, it's not in our respectful submission encompassed within 112.2.
No, I can see why
Clearly, of course, but Section 46 would be capable of dealing with any rectification which followed, because if it's happening in the liquidation, the liquidator can make an application to the court, and it's relatively simple to do that. Also, the power of rectification is in relation to the questions of contributors and calls being made on contributors. It may have been felt that that's almost had become somewhat vestigial, but certainly by the time we're looking at 112.2, we're not looking at any question of making calls or contributors. We're looking at a small subset of companies, solvent liquidations, and a general power of rectification, which in our respectful submission is quite distinct from the power of rectification in Section 46. And just so your lordships have the background so far as the Cayman cases were heard, Justice Jones said there was no precursor to 112.2, and he said that at page 1192 at paragraph 22 of his judgment. And I'd ask the court to note that Justice Jones chaired the committee which brought forward the amendments which are contained in the 2009 review of the Companies Act.
Were the rules done at the same time?
The rules were done at the same time, except for subparagraph 5 of Order 12, Rule 2, which we'll need to look at, which came in slightly later. But the rules were done at the same time, and Justice Jones was also on the Insolvency Rules Committee.
So there would be a committee overlap, but it wasn't identical.
I don't think it was identical, but certainly to the extent that we rely on Justice Jones and what he says when he says 112.2 has no precursor, we respectfully submit he's right. And that point was taken up by the Court of Appeal in the Cayman Islands in paragraph 3 of the judgment of the Court of Appeal, where Sir George Newman observed the novelty of these provisions. And it might just be worth, if I can ask the Court to look at page 1866, which is in Bundle 6, tab 35. Paragraph 3, the Court said, open-ended investment companies have been popular and important vehicles in the provision of financial services in the Cayman Islands, and the fraud on this scale affecting several companies could be seen as giving rise to far-reaching consequences for the orderly administration of company liquidations. I should observe that Madoff fraud was not the first fraud in the fund. It was the biggest at the time it happened in 2008. Principally, it must have been obvious that there would be complex and novel problems for liquidators to resolve in connection with the distribution of surplus assets. Legislative action was taken, amendments were introduced to the company's law and the company's winding up rules. And then I'll just skip to the end. It's clear that the legislature intended to effect a notable change in the law, but the meaning and extent of the change introduced by the terms of 112.2 has given rise to the controversy this Court must resolve. And Lord, my ladies, those are, in our respectful submission, correct statements as they appear, because one looks at 112.1 in its old form, 112.2, which has gone to another part of the company's law, and one looks at 112.2 in the 2009 form, and it is entirely new. And at the same time, the Insolvency Rules Committee produced the company's winding up rules, which can be seen at page 2367, or Bundle 9, tab 9. And Order 12, Rule 1, we looked at very briefly, deals with 112.1. And then Order 12, Rule 2, provides...
I'm so sorry, I've got the wrong page number.
Oh, it's 2367, my Lord.
Thank you. Yeah.
2.1 says the official liquidator shall exercise his power to rectify the company's register if he's satisfied that, and then the company will become solvent. And then the company has from time to time issued redeemable shares at prices based upon a misstated net asset value, which is not binding on the company and its members by reason of fraud or default. Now, my ladies and my lords, we don't rely on Order 12, Rule 2 as our route to rectification. We rely on 112.2, but we do submit that the production at the same time as the 2009 revision is something that needs to be looked at side by side with 112.2. If the conditions in Rule 2.1 are satisfied, then subject to paragraph 3, for the purpose of rectifying the register of members in accordance with the rule, the official liquidator shall determine the true net asset value of the company at each relevant redemption date. And then paragraph 3 tells the liquidator how to determine the true net asset value. And then subparagraph 4 sets out what the register should look like when that exercise has been done. So the register is to state at each relevant redemption date the identity of each subscriber, the amount of money subscribed, and the number of shares which ought to have been issued. Little b does the same thing in relation to redemptions. And then little c, the identity of the company's members, and the number of shares which ought to have been held by each member, so enabling distribution to take place on that basis. And the company's share register shall be rectified accordingly. And that was how Order 12, Rule 2 appeared in 2009. And then, as I understand, in 2010, it was amended, again by the Insolvency Rules Committee, obviously, to provide if the official liquidator considers that it will be impractical or not cost-effective to rectify the company's registered members in accordance with paragraphs 2 and 3 of this rule, he shall nevertheless rectify the register in such manner which is both cost-effective and fair and equitable as between the shareholders. So at that stage, the liquidator could say, I can't do it the way, I can't do it on the basis of a true net asset value. But if he can devise a way which is cost-effective and fair and equitable as between the members, then that's what he will do. And note that in the context of Order 12, Rule 2, this is a mandatory rectification.
Yes, he shall nevertheless rectify the...
Yes. Whereas we say 112.2 is a power, we say Order 12, Rule 2 doesn't exhaust the occasions when that power will be exercised. It clearly contemplates that there is a power which will be exercised when necessary. There's an element of discretion for the additional liquidator subject to the supervision of the court, but that in this circumstance, he must.
So remind me why you say it doesn't apply here.
Well, we say it doesn't apply because the NAVs in this case in Herald are binding, because it's an external fraud case.
I see. So that you do accept that distinction between external and internal.
We accept that, and we say Order 112.2 operates even when the NAVs are binding. It gives the liquidator the power to rectify the register.
But it helps to the extent, I suppose, that it accepts that the concept of rectification can include doing what is just and equitable.
Yes.
So it's not
Yes.
purely mechanical.
Yes, we say we're not relying on this rule to get us to where we want to get to, but we're saying this shows us what sort of rectification the legislature must be taken to have been thinking about in 112.2. And one instance, we say the power is wider. Order 12, Rule 2 is an example where the power must be exercised. And it's clear that the rules contemplate that the power is wider because the appeal process, which is set out in Rule 4, at page 2369, says any member or former member of the company who is dissatisfied with the official liquidator's decision to exercise his powers under 112.2 or the manner in which he's rectified the register may appeal to the court. Now, it would be odd to have a power to appeal the exercise of the power under 112.2 if the only occasion when that power could be exercised was when it was mandated by Order 12.2. So we say 112.2 creates a space for rectification. Order 12, Rule 2 is one instance in which in relation to which the power must be exercised. And we also say, by reference to Section 59 of Benyon, which is at page, is in the Authorities Bundle 12 at tab 66.
Although it doesn't appear to give a member or former member of the company a right to appeal if the liquidator decides not to exercise the power.
Well, 112.3
in a very one-sided way.
112.3, if we go back in Bundle 9 to tab 6, this may not
Satisfied with the liquidator's determination.
Yes.
That's a contributory.
Yeah, contributory.
Yes.
But 1 and 2 make a big distinction between contributors and members. So it would be, on the face of it, an odd construction to say that 3 is about 2.
Yes.
Unless the member is also a contributory,
yes.
which in an open-ended investment company is highly unlikely.
Well, he's not going to be liable to contribute.
No, so he won't be a contributory in the sense in which it's being used here.
Is a fraction of a dollar. So we're left with Order 12, Rule 4.
There must be some wider general power to apply to the court in a...
All liquidations are subject to the supervision of the court, and all liquidations will have the ability of a member to apply to the court, say they're dissatisfied with the conduct of the liquidator. So a failure to do what the liquidator should, I mean, obviously under 12 Rule 2, if the liquidator doesn't do what he is required to do, that would be an obvious case. But if there were a very strong case for rectification because some asset had been fraudulently valued by a sub-fund, then the liquidator does what he does subject to the supervision of the court. Of course, in this case, the liquidator was mandated right at the outset under the terms of the winding up order to look at these very issues.
Well, yes, but yes.
I mean, certainly the way liquidations work in Cayman, so liquidation on this scale, is the court has a very tight control over what the liquidator does and what he spends and what he charges. And so that's part of the context in which these provisions have to be seen.
Could you just help me by rewinding a moment?
Of course.
If we are to take from section 112, 1, 2 and 3, that only a contributory is given an appeal by that section,
yes,
and a contributory does not include the member who's dissatisfied under subsection 2, his right of appeal only comes through Order 12, Rule 4.1.
Yes.
Right.
Yes.
Well, but you say subject to the fact that
anybody
can invoke the court's general power of supervision.
Yes, if a party says, I'm aggrieved by the conduct of the liquidator.
But in specifics, that's
so far as the rules are concerned, those are the gateways, if I can put it that way, which are laid out. So, as I've submitted, these are brand new provisions.
Were they the subject of some report to the legislature?
Well, my lady, there is a report to the legislature, and that's part of one of the additional authorities which my learned friends put into the court, I think, yesterday. And there is, if we look at that, there is nothing said which is relevant. In fact, there's nothing said about 112 at all, which is quite surprising. Page 28 of the additional, or the supplemental agreed authorities bundle, page 28 is part of the report. And clearly, I have to deal with this point. But what we respectfully submit is that the focus of this appeal is on the wording of 112.2. The fact that the report doesn't say something about it is something that can't take one very far. There doesn't seem to be any...
Section 112 doesn't feature at all.
It doesn't, no. There are quite big changes are made to 112. But my Lord, we respectfully submit, we want to agonise over what's not said in a report. What we've got to look at is the words of 112.2.
What it is, you said, is Justice Jones was party to the report, and
yes, yes.
He doesn't explain why.
Well, he wasn't asked to explain, and we should have done. But certainly when he comes to look at this case in 2015 and 2016, he says, this is a new power, and he articulates it in a way which we respectfully submit is right, although he didn't go far enough.
No, I mean, those of us who've been involved in Law Commission reports are quite prone to mention in our later judgments their significance. But
it's a confession on the part of the Lord.
Very happy to hear it. But, and it may be that was what Mr. Justice Jones was doing. Yeah. But he certainly didn't feel any...
Is there any reference in Hansard in
no.
the Cayman legislature?
Whether the legislature would have taken a keen interest in the detail of the revision is... I'm not certain whether it's something which...
Sure, the practicing profession in Cayman would have taken a very close interest.
Yes, but then they don't sit in the legislature.
The elected members knew how important it was.
Yes, this was quite a large-scale revision, and this particular clause, as we know, relates only to solvent liquidations of a particular type of company. But we respectfully submit that the absence of any flagging or fanfare for this section can't be taken to mean one has to read it as not signifying what the words on their literal interpretation actually mean. And this is not just unconscious, unintended consequences of moving wording around into different places. This is making a provision which deals with only solvent liquidations of funds and provides for power to rectify the register of members. And so unless one is going to neutralise or in some way strain against the literal meaning of those words, in our respectful submission, they should be taken at the values that the ordinary natural meaning of those words gives you. And we say, on page 3434, we have a quote from Benyon, but literal meaning is how one starts off looking at the words of a statute of this kind. And it's, as we say in our written case, it's open-textured language, and it provides for a situation of the kind which we have with Herald. It's given to, in this case, the additional liquidator. It's a power to settle, if necessary, rectify, thereby, by the process of rectification, adjusting the rights of members amongst themselves. And we've quoted, but I don't think one really needs to go into it. Rectify has a meaning of putting right, correcting, removing error, reforming, etc. And in our respectful submission, in the context of shares issued at NAVs, and particular problems which arise when NAVs have been misstated, and distribution is going to take place of surplus asset based on misstated NAVs, then it's clear what the focus of the rectification power is. Because at the moment, the register reflects and mirrors the Madoff fraud. This section clearly envisages the reconfiguration of rights. And as I've already said by reference to Justice Jones and the Court of Appeal, it's new. And in our respectful submission, the word should not be approached in an a priori reductive way. One shouldn't read rectification as having a meaning which can't encompass the rectification here, because the context in which the word is used is important. There is no concept of rectification. Rectification appears 2 times in the Companies Law, one in section 46, one in 112.2.
And in section 259, rectifying the beneficial ownership register.
Yes. And in our respectful submission, 112.2, as I've already submitted, operates in a wider range of situations than Rule 2.1. And that was the approach of Justice Jones in his first judgment, which was that Order 12, Rule 2 is an instance of where the power of rectification must be exercised, but it doesn't exhaust the power of rectification. And if it had been intended that Order 12, Rule 2 was the be-all and end-all of 112.2, then the statute, as Justice Jones said in his first judgment, the statute would have said so. It would be very strange to create a general power and then, under the rules, circumscribe that power, because effectively the secondary legislation would be overwriting the primary legislation. And in our respectful submission, the factual context in a case of this kind is very similar to the factual context in an internal fraud where you could rectify the register. This situation is materially, factually similar to the situation where members are members of a company where there's an internal fraud. Order 12, Rule 2 applies where there are misstated NAVs. We say that's the situation which 112.2 also works. So far as members are concerned, an internal fraud and an external fraud produces the same result in this case. The rights expressed in the register are the product of the Madoff fraud. And in our respectful submission, although there is, and we acknowledge, a fundamental difference between an internal and external fraud, as between the victims, there is no moral but only a legal difference between them. And in our respectful submission, 112.2 addresses that and enables the liquidator, subject to the supervision of the court, to prevent distribution effectively giving effect to what the US court called the machinations of Mr. Madoff. So Order 12, Rule 2 is helpful to show where this is going, but it doesn't exhaust the policy. It doesn't exhaust.
The concept in Order 12, Rule 2, 1B of a non-binding NAV, to what extent, what's the timing as between the formulation of this rule and the decisions of this board about the generally binding nature of NAVs and the
These predate.
These predate. So
yes, I think
it's fair to say
Fairfield
the concept of internal or external fraud as, if you like, governing when a NAV is or is not binding in a standard form set of articles of an open-ended investment company, which provides for it to be binding.
Yes.
Wouldn't have been something yet, unless they were prescient, thought through by the Rule Committee.
No, certainly they wouldn't have had Fairfield Sentry and
No.
cases of that kind in mind. They would have had frauds in funds in mind, and they would have had articles that provided for NAVs to be binding. But just taking on your lordship's point, I mean, there is an oddity in Order 12, Rule 2.1, provides that NAVs not being binding by reason of default, which is quite a strange use of language. And one can see why fraud would unwind a NAV, but why default, which is such a loose term, is less easy to see.
Well, there may be some provision requiring due diligence by the directors or something.
Yes.
But the date on which this was enacted was not the date on which it came into effect, was it?
No. In effect in 2010. And can I correct one thing I said earlier, which is in relation to the definition of contributory. Contributory is not limited to somebody who has an amount still to pay on a share. That was my mistake. A contributory includes, under Section 89, every holder of fully paid up shares of a company. So the contributory does have a gateway to appeal under subsection 3 of 112.
That makes it even more odd, the use of the word member in
Yes.
112.2 rather than contributory.
Well, I suppose it's focusing at 112.2, what we would submit is it's focusing on the register of members at that stage. So it's never mind contributories, which is 112.1.
Can you just give me the definition section again?
It's Section 89.
Thank you. Is that in the bundle?
It isn't, and we'll make sure it's with the note that we're going to produce. In our respectful submission, our interpretation gives 112.2 a purposive construction. It's to enable the liquidator to resolve complex and novel problems. That's what the Court of Appeal identified as the scope of activity for 112.2. And this, in our respectful submission, is a paradigm case for the existence and exercise of the power. And that was the view of Justice Jones in his judgment in September 2016 at page 1193. And he made the point, which in our respectful submission is a valid point, that although Herald wasn't a Ponzi scheme, it was, in effect, a kind of proxy Ponzi scheme because it mirrored the effect of what Madoff's fraud did with valuations. The interpretation of Primeo will require distribution to take place in accordance with the effect of the Madoff fraud. There's no doubt about that. And in our respectful submission, that would be a regrettable occurrence. We say Order 12, Rule 2 is just an instance, 112.2 is broader. And in relation to the policy, we respectfully submit that can be derived from subparagraph 5 of Order 12, Rule 2, and from the context generally, which is this is all about misstated NAVs. And the obvious policy of the statute is to produce fairness between the remaining members to enable the oppressive consequences of the fraud, the terrible detriment identified in the US authorities, to be mitigated. And in our respectful submission, if one asks oneself, well, what is the policy to be derived here? One asks oneself, why has the power in 112.2 been created only for companies which have issued shares from time to time at a variable NAV, and only where those companies are in solvent liquidation? The answer must be that the legislator has identified a problem, and that is that if shares are issued at the wrong NAV, in a solvent liquidation, distribution will take place on the footing of that wrong NAV. And this rectification power is very far from being a reproduction of Section 46 in the context of liquidation. It's not, in a sense, it's very far from Section 46, and its limited scope tells us that. It's just, and then one has to ask oneself the question, is it just to resolve the Order 12, Rule 2 problem? So that's a problem when the NAV is not binding by reason of fraud. We say no, because that's not a problem that it would be worth legislating for, but it's a problem that general law already would cater for. So the purpose in our respectful submission is to tackle the unfairness that results from distribution based on an incorrect NAV, an incorrect register based on misstated NAVs. And the underlying guiding principle one can see from Sub-Rule 5 of Order 12, Rule 2, is to produce a fair and equitable result amongst the members. And we respectfully submit, one not just does that piece of self-interrogation in relation to 112.2, one ends up with a coherent and effective role for the section to perform. Now, it's objected, many objections are raised, and I can't deal with all of them in the course of my opening submissions, but it's said that what is being done is to subvert the operation of Section 140 in the mandated scheme of distribution according to members' rights at the commencement of the winding up. And it's objected that no other jurisdiction has this provision. Well, in our respectful submission, that's as may be. The Court of Appeal rightly didn't give much weight to that submission. The Cayman Island legislation does have this provision. It does have an important funds industry. And in our respectful submission, 112.2 is the answer which the legislature has provided in relation to this point. So our submissions are that neither the language nor the policy of 112.2 provide any basis for construing it as if it went no further than Order 12, Rule 2. So first point, it's broader than Order 12, Rule 2. And the power is given to the liquidator to settle and rectify the register of members whenever this is necessary to achieve a just outcome to remaining members who will participate in the solvent liquidation. And the power extends, as Justice Jones was right to say in his first judgment, to varying the existing legal rights of members, because that's what the words of the section say. There are no a priori limitations which one should bring to the interpretation of this section. It can be exercised when the NAVs are binding, and the exercise of the power in this small category of cases is subject to the supervision of the court at all times. My lady, on that basis, we respectfully submit that this was a paradigm case in which the power should have been exercised. Justice Jones was right about that. Distribution on the basis of the register as it is will simply cause to ossify the arbitrary and unfair distinctions drawn between members as a result of the Madoff fraud. Leaving the register as it is demonstrably unfair. Doing the best that the liquidator can with the information he has is clearly what 112.2 in our respectful submission is about. Now, Primeo say if there is a discretion, it shouldn't be exercised. In our respectful submission, that's plainly wrong. This is a textbook situation, and a very rare situation, but it's a textbook example of what this section is intended to do.
Can you just help me, going back, the relationship of Section 112 and Order 12? Order 12 is made under the general powers of the company's rules. No, it's not specific to... But I mean, the point I'm getting at is, I take your point that Section 112.2 is in discretionary terms, power, and therefore on its face not limited by the example given in Order 12, Rule 2.
Yes.
But Order 12, Rule 2 clearly works on the assumption that having decided they've got to exercise a power, it needs to set out the principles on which that is to be exercised in 2 to 5.
Yes.
Now, why would that not have been necessary in this sort of case? Surely you would need that sort of guidance in any case.
The general power could arise in a number of different situations. This power is when it's mandatory, it's only one particular situation, and so, if you like, what's set out is what, if you must do it, this is what you must do. If you have a discretion as to what to do, then our submission would be that the statute leaves it open as to how the liquidators to do that, subject to the supervision of the court. And there's no reason why the liquidator shouldn't use Order 12 as a guide, but it's not setting out the recipe, if I can put it this way, for what he must do if he's mandated under Order 12, Rule 2.1. And my lords, Order 12, in a way, oscillates sometimes between being self-contained and talking about if, for example, in sub-rule 5, if it's impractical or not cost-effective to carry out the rectification in accordance with paragraphs 2 and 3 of this rule, so that refers back to within the rule. But then paragraph 4, which deals with the appeal, focuses on the liquidator's decision to exercise his powers under section 112.2. So that clearly contemplates that there is a scope for considering whether to exercise and then exercising under 112.2, and the tighter mandatory set of steps that the liquidator must take if the NAV is not binding for reason of fraud or default.
It's also apparent, isn't it, that section 112, subsection 2, does not limit the power to that which is more particularly set out in rules.
No. So I think the Rules Committee is probably saying there are a number of situations in which this power ought to be exercisable. One is fraud, in which case do X, Y, and Z. The others are, well, we don't know completely, so we shouldn't be setting out a template for what's to be done. That's something which is left to the liquidator, exercising the power to do under the supervision of the court with a right of appeal to any member who's aggrieved by his decision.
It is nonetheless quite odd that if the Rule Committee, including Justice James, has been involved in the changing of the law itself, thought that actually, for the purposes of the availability of the power, it didn't matter whether the NAV was or were not binding. One would have expected them to be more concerned to legislate and provide detailed guidelines in a situation where it was than where it wasn't.
Well, again, I suspect all legislation, when put under this kind of focus and spotlight, can be seen to have gaps in it and things which one might have done but hasn't done. But our principal point is one can't read 112.2 down by reference to what's in Order 12 Rule 2 and say, well, that's all it does, and it's only when fraud has caused a NAV not to be binding. It's clearly broader than that. It may be that the Rules Committee were going to get round to something of that kind.
It's not exactly a travaux préparatoire to the making of the change in the law, but if it's done at the same time, it's a sort of contemporary travaux.
Yes.
It might shed some light on what they were doing when they were changing the law.
It's a snapshot, but whether it shows you the full picture, I think one has to be careful not to derive too much from that. But here, of course, the language pushes in the opposite direction. The language is one which gives a power, and that power is within the limited range of discretion that the liquidator has, subject to the supervision of the court, one which is left to the liquidator in all cases bar one, in which case do what's in Order 12 Rule 2.
Is there actually authority? I mean, they may be taking into account the sort of total package where you've got a sort of legislation which is produced at the same time with some rules. I sort of have at the back of my mind there may be, but no.
I'll check on that. We put a lot of Benyon in the bundle, but I don't recall any passage that deals with that. But
the distribution as between the Act and the rules in England is quite extraordinary in the sense that there are fundamentally important provisions of substantive law in the rules, such as the rules about set-off, and all sorts of bits and pieces about procedure in the Act. So that in a sense it's an extraordinary mixed bag that can only really be understood by reading all of it.
Yes.
I wondered if there's any similar oddities in the relationship between the Act and the rules in Cayman.
There's nothing else in these rules which are going to help us with 112.2. That's for certain. The other provisions of the Covenant is winding up.
We see it in relation to the right of appeal, where one of the rights of appeal is in the Act.
Yes.
In the rule.
Yes, and you've got you've got either two different rights of appeal with a mechanism set out in sub-rule 4 or a general right in 112.3.
Well, presumably you would argue that where the rules deal with the same general subject matter as the Act, it's sensible to read them both together.
Yes, but what's important there is sub-rule 5, which, as I pointed out, was not produced at exactly the same time as Rules 1 to 4, but came, I think, a year later. But Sub-Rule 5 shows very clearly, in our respectful submission, what the exercise is about. So, for example, if it were said, as Primeo does say, you can't identify the true NAV in this case, therefore you must stick with the one which you know to be wrong, Sub-Rule 5 deals with that. And Primeo's only answer to that is to say, well, it must be ultra vires, but we respectfully submit there's nothing in that.
Right. Well, let's move on then.
Yes. So we say this is a case where the power should be exercised. And the method of rectification is dealt with in our written case. But essentially, the approach which has been taken has been very much guided by Sub-Rule 5. And it's what we call the net investment method. We respectfully submit that 112.2.2 gives a wide power. It's not prescriptive in the same way as Order 12, Rule 2. And although we're not dealing with Order 12, Rule 2, we can still look at the ultimate goal in subparagraph 5 to guide what this exercise is about. The evidence shows that the additional liquidator cannot assess the true NAV of Herald, which is its notional claim against Blimis at any time at every valuation date, partly because the trustee in New York has not done that exercise of working out what the value of the funds was or the claims were at any given time. We respectfully submit that net investment produces the fairest and most equitable result. And it's dealt with in the evidence at page 1917 and 2171. And so it reflects the method which is being used in the US.
Yes.
And it involves identifying each member's net investment in Herald. So that's the sum of money they put in less the sum of money they got out until Herald suspended its NAVs. And with each member, you then get an aggregate of what the net investment is, and then you work out what the proportion of each member's share of the aggregate is. And then that's the shareholding which is attributed to them.
But there's no account taken of the passage of time, no interest was awarded?
No, there isn't. Herald was a fund that traded for about 4 years. It started in 2004. So though there is an appreciable passage of time, no calculation has been done to pick out the difference between somebody who invested in day one and somebody who invested in day -1. And then the register is restated in relation to those proportions. And then distribution takes place in accordance with that methodology. And that methodology is explained in a case called Huber, which is at pages 2328 to 2329 in the authorities bundle. But I don't think we need to go to it.
So which bundle is that?
That's in the authorities bundle, my lord, the bundle 11. Sorry, no, I'm sorry, I've given you the wrong way.
We don't have a bundle.
Yes, it can't be 2328, can it?
That gives us a reference to the case.
Yes.
Which is said to be 3265.
Yes, no, the case is at tab 60.
So which tab?
It's volume 12, tab 60.
60.
It's 3265.
Thank you very much. And the relevant passage is at the bottom of page 3265 down to the bottom of 3266.
Well, the last two lines on 326.
The last two lines on 3265 and then over the page of 3266. The judge in that case looks at both net investment and rising tide.
Oh, yes, he gives an worked example.
He does give a worked example, and my learned friend set that worked example out, except he's got the figures wrong. But if one reads from the authority, it's clear. Each person gets the same share, the same percentage proportion of their loss as each other. So depending on... but we set out in our written case what the steps are. And we respectfully submit that it's the appropriate method to use in this case because it's based on the one measurable common feature, which is the money in and the Everything else in this case is smoke and mirrors. No other value is going to yield anything which is useful to the exercise if it's to be done in a way which is fair.
Well, the rising tide method is equally objective, isn't it?
The rising tide...
It's rather more aggressive.
It has great merits, but it's driven by recoveries, whereas a net investment method simply freezes a frame at a particular moment, and you will get that percentage of recoveries. Rising tide enables people to participate, in some instances, only when the recoveries get to a certain point. So as more recoveries come in, more people may become eligible to recover. So the additional liquidator would favour rising tide because it's fairer, because it takes into account what people have received in their participation in recoveries. But one cannot draw a register at a given moment in time because it would have to keep changing as more recoveries came in. So it's a better system, but it's not one that fits within the framework of what the additional liquidator has to do under 112.2. We respectfully submit that this is an appropriate method to adopt. It doesn't subvert Section 140 at all. It's simply a preparatory step to distribution in accordance with Section 140. It doesn't ignore the share register. It simply takes that aspect of the share register which deals with amounts paid for shares and gives it the objectivity necessary to determine what the rights of individual members should be. The continued harping on of the impossibility of defining true NAV in this case is, in our respectful submission, a complete red herring. True NAV is simply a way of saying this fraud is so good and so successful you can't find the right answer, therefore live with the wrong answer. And in our respectful submission, that's not what 112.2 is all about. So we say net investment method, as articulated by the additional liquidator in his evidence, is the right way of determining how the register should be rectified.
If I'm the liquidator, how
Yes.
do I know this from section 112.2? How do I know what test I'm applying to decide A, whether to, and B, how to?
The liquidator has to look at the facts as he finds them. And he's in the same position as he would be under Order 12, Rule 2, where he's told, find the true NAV, this is how you do it, but given the possibility, well, if you can't do it that way, do something which is cost-effective and fair and equitable.
So he's reading 112.2 with the order
Well,
to get
he sees, Milady, the way we'd put it is that the 112, Order 12, Rule 2.5 is a very good way of seeing what the policy is behind 112, Rule 2, in that process of self-examination of what is 112 getting at, what's the policy behind it. And if the liquidator understands that, and of course he's doing this exercise, or she's doing this exercise under the supervision of the court, if the liquidator bears that in mind, then that policy is one which the liquidator will articulate.
I suppose you might say that if the liquidator has a discretion, it would be unusual that he or she should not exercise the discretion in a fair and equitable manner.
Yes, because
even without statutory stipulation.
Yes, but the statutory stipulation in Sub-Rule 5 shows, if I can put it this way, the degree of flexibility that was intended to operate within this.
You have to analogize from Sub-Rule 5.
Yes, but my Lord, and my ladies, I would also go on to say, just going back to those questions one asks oneself about the policy, what's it addressed to? Why is it being created for solvent liquidations of companies of this kind? It's because of the dangers of misstated NAVs feeding their way through into the distribution of surplus assets. And so that's why this has got nothing to do with Section 46, it's why it's doing something else, and it's addressing a policy in a very limited set of circumstances, but one that's important for the jurisdiction in Cayman. Because I'm conscious of the time, that we respectfully submit that the power under 112 Rule 2 can operate in a number of different situations, as I've already submitted. And we respectfully submit that it's wide enough to be exercised in the case of the in-specie subscription. Because the issue here is, does the power in 112.2 give the additional liquidator power to rectify the register to reduce the number of shares allotted to Primeo when it invested by transferring its account in Blimis to Herald? The statements in relation to, the facts in relation to that at page 2233, paragraphs 21 and 41, an excessive number of shares was issued because Herald thought the account that was being transferred was $465 million worth of securities. It turned out to be $149 million of net investment at the point of the in-specie subscription. Mr. Justice Jones observed in his paragraph 32 of his September 2016 judgment at 1197 that if one used a net investment method, then that would simply be a way of dealing with the in-specie subscription. He balked, in our respectful submission, wrongly at using the net investment method. But if one uses the net investment method, one simply looks at what was the net investment of Primeo and Blimis at the time of the in-specie subscription, and one applies it in this case. And so the share, from recovering 3 times as much as they should, they recover something which is consistent with their net investment. So in our respectful submission, we don't argue against cases which suggest that one can't go behind or question the adequacy of non-cash consideration. We simply say that 112.2 overrides it. Those considerations are immaterial to the width of 112 Rule 2. And in our respectful submission, it's a power that can be exercised in respect of any subscription in circumstances where there's an injustice as between the remaining members of the company, which can be mitigated by rectification. It can arise in a number of different situations: misstated NAVs because of fraudulent valuations from Blimis, or an overvalued subscription because of fictitious valuations by Blimis. It's the same fraud that affected both the subscription and the in-specie subscription. And so in our respectful submission, the power is wide enough, and essentially I can reduce our submissions to this, that the power in 112.2 extends to settling and rectifying the register of members so as to vary existing rights for the purposes of achieving justice as between the remaining members in a solvent liquidation. All the subscriptions and redemptions of shares in Herald were transacted on the basis of fictitious NAVs. The consideration by Primeo was also overvalued as a result of the same fraud. And Herald's register is the product of a combination of subscriptions at fictitious NAVs and the in-specie subscription. The application of the net investment method calculates each member's shareholding by reference to their financial contribution to Herald. And it's the closest the liquidator can get to a register which is fair and equitable as between the members. Just one further point. Lady Black referred to Section 259. I understand it's a 2018 provision, so I wasn't as wrong as I thought I was. My lady, is there anything else I can assist you with at this stage?
And there's clearly been a policy decision by the legislature not to permit or authorise or require the liquidator to take clawback actions against those who got out, the winners. There
are no clawback provisions, and in relation to Herald's NAV, there would be no basis on which redeeming members who got out could be asked to pay back. I mean, Weaving was a case where there was a preference, and so there was the ability to get money back. Which
yes, paid out. But if there's no special rule allowing avoidance of a transaction, they're left with the loss lies where it falls.
They are effectively the lucky ones, which for all Ponzi schemes will have winners and losers. This case is all about trying to level the playing field between a set of losers. Thank you very much.
Thank you very much. Mr. Slot? No, Mr. Smith.
Thank you, my lords and my ladies. As you know, this case turns on the correct construction of Section 112.2, and in particular, the meaning of the concept of rectification of the share register, which is provided for in that section. In our submission, the appellant suggested construction of the section is wrong. We submit rectification in Section 112.2 bears what we would say is its normal meaning, including the meaning which it bears elsewhere in the same company's law, specifically in Section 46. We say what it does is permit the share register to be amended so that it reflects as a documentary record the true legal position. But what it doesn't do itself is confer any freestanding substantive power to override or vary legal rights so as to enable the rewriting of the share register. And and we'll come to this, but we do submit there's no basis, whether in the statutory language or in anything else, including the legislative materials, for thinking that the Cayman legislature intended to confer what would be a novel and far-reaching power on a liquidator of an investment fund, effectively to override or vary the proprietary rights of shareholders in an investment fund in order to reflect his own view, his own subjective view of what justice requires in any given case. So that's an overview of our case on this appeal. For the purposes of these submissions, what I was proposing to do was spend a little time just looking at the background and history to section 112, because in our submission that's helpful and relevant in understanding it. Secondly, I'll deal with our case on construction, which I can deal with briefly. We then have a number of reasons why the appellant's construction is, we say, wrong. And then finally, I was going to deal with the question of distribution methodologies and also with the in-specie subscription. So dealing first with a little bit of the background, in our submission, in construing section 112.2, it's important to have regard to the rectification jurisdiction as it stood prior to those amendments. The amendments didn't take place in a vacuum. There was an existing piece of legislation there. And section 112.2 in our submission wasn't a wholly new provision. The concept of rectification of the share register was well known and well established, including in section 112 itself. And in our submission, section 112 sub 2, as amended in 2009, is really a development or modification of what was already there, rather than an entirely new provision. We disagree with the suggestion it's entirely new. It's new in the sense that there wasn't a provision in exactly those terms before, but the concept of rectification was already there in 112.
So why did they bother adding section 112? Because the legislature must be presumed to change the law when it enacts a new
Yes. Yes, so the purpose of the amendment to section 112 was it basically did two things. In the case of the settlement of the list of contributories, it meant that the liquidator could now do that rather than the court. So that was the first change. The second change was that in the case of investment funds, the liquidator, rather than the court, could rectify the register of members. And principally, the changes were driven at the identity of the person who first of all had to settle a list, and secondly, allied to that, who could rectify the register of members. That was the reason behind the changes. But I'll show you, perhaps that becomes a little clearer when we look at the background. So for those purposes, I wanted to start, if I could, with the 1862 Companies Act, and apologies for going right back to the beginning, but we do think it's helpful just to see how some of these provisions have developed. You'll find that in volume 12. So, sorry, no, it's not in volume 8, it's in volume 9, I think. Behind tab 20, and if we go first of all to 2406. 2406.
Yep.
Now, this is section 35 of the 1862 Act, and this is what I'll refer to as the general rectification jurisdiction, if you like. It's a power given to the court to rectify the share register. It applies in or out of winding up, and it's a power that arises on the application of a person or member who is aggrieved, or a member of the company, or on the company itself. So it's basically a power which is given to the court, and arises on an application being made by a specified category of persons. And as I say, that applies generally. It's not a provision that's limited to winding up. Now, Part 4 of the 1860...
Has it been held to apply in a winding up?
Well, I'm going to come to this point because some of the cases, which I'm going to come to in a moment, deal with the relationship between section 35 and section 98, which deals specifically with rectification in the winding up. But they do suggest, and Buckley supports this, and that Section 35 would apply in a winding up. I'll show you that in a moment. But before we go there, I was just going to show you the other relevant provision of the 1862 Act.
It is headed remedy, isn't it?
It is, indeed.
It is only a procedural provision because the court has power to rectify in an action. This simply enables you to go under this particular procedure, which is a summary procedure.
Exactly. And rectification, we say, wherever it appears in the Companies Act, bears the same meaning. And basically, it's looking at rectifying the documentary record, the share register, so it reflects the true legal position of substantive rights. I was going to show you then Section 98 of the 1862 Act, which you'll find in 2408, behind Divider 21. And this appeared in Part 4 of the 1862 Act, which dealt with the winding up of companies. And you'll see Section 98 applies after an order's been made for the winding up of the company. The court shall settle a list of contributories with power to rectify the register of members in all cases where such rectification is required in pursuance of this Act. So this was a specific rectification power given to the court associated with the settlement of the list of contributories, and it applied specifically in a winding up. And it's Section 98, which is the direct predecessor of Section 112, which is the provision at issue in this case. Now, the rectification power in Section 98 and its successors has never been considered to confer on the court some kind of substantive power or jurisdiction to rewrite the register of members of a company which is being wound up. In my submission, rectification in Section 98 and its successors has been understood in exactly the same way as it's been understood in relation to Section 35 and its successors. And that may not be surprising, given that they're cast in the same language. And specifically, we say Section 98 served the function of providing that the normal power to rectify the register of members, which we saw in Section 35, continued to be available after the commencement of a winding up, and specifically that it's available as part of the process of settling the list of contributories and doesn't depend on an application being made by one of the categories in Section 35. Now, in support of that, there's a couple of cases from the late 19th century which touch on the relationship between Section 35 and Section 98, which I'd like to take you to, if I may. The first is a decision called London, Hamburg and Continental Exchange Bank, and you'll find that in volume 10, divider 39, 2779. And this was a case for rectification which was brought under Section 35. But what's relevant is what Lord Cairns says at page 441, 2789 about the relationship between Section 35 and Section 98. Because you'll see, well, perhaps actually if we can just go to 2788 first of all. Halfway down the page, in the paragraph beginning, I think it clear, he describes the purpose and object of the rectification jurisdiction. He says, I think it's clear that the object of these enactments was to secure a list or register which, supposing it to be fairly and properly kept by the company, in accordance with the authorities and documents of title furnished to them, would show at any time who were the shareholders entitled to the profits, liable to contribute to the debts of the company. And that's something that's then picked up by the Privy Council in the Nylon case, essentially in support of the proposition. Rectification jurisdiction is designed to ensure the share register, as a register, properly reflects the true legal position. And he then says at the bottom of the page, it was further necessary to provide for the correction of errors in the register occasioned by the default of the company. This has been done by the 35th section, and this, in my opinion, is the scope and object of the 35th section. And by the 98th section, the power given by Section 35 may be exercised not only before a winding up of the company, but also for the purpose of settling a list of contributories upon a winding up. So he sees Section 35 effectively as being applied in a winding up in relation to the settlement of the list of contributories by Section 98. And that's the relationship between the two.
The list of contributors is something different from the register.
Oh, of course, absolutely, because the list of contributors would, for example, include a former member who's liable to contribute. Section 49, no, absolutely. But one can see that in order to create the list of contributories, which would include current members, one may need to rectify the register as part of that, because a correct list of contributories is going to depend on having a correct list of the register of members. So one can understand why the draftsman of the 1862 Act put the two together like that. Now, the other case which touches on this point is a case called Sichel's case, which is in volume 11, behind divider 55, at 3185. And this was a case where the official liquidator applied for rectification of the register in a winding up. So it was a case where there was a winding up on foot. And the question which arose was whether the register should be rectified to record transfers of shares to a Mr. Sichel so as to place his name on the register. And he was someone who'd been a mortgagee of the shares, and essentially the official liquidator wanted the register rectified so that he would be placed onto the register, no doubt that so he would be liable as a contributor that weren't fully paid up. Now, the application was refused, essentially on the basis that it was said the official liquidator, as the representative of the company, had no standing to seek the rectification. But again, what's relevant and helpful for our purposes is just what the court said about the relationship between Section 35 and Section 98. With that in mind, if you could go, please, to page 3187. Which is page 121 of the report. And you will see roughly halfway down, there's a paragraph beginning in the above circumstances.
Sorry, 3187.
3187, page 121 of the report, about halfway down,
Yeah.
just above where the arguments of counsel begin to be summarised. There's a paragraph that should say, in the above circumstances.
Yeah.
So, as you can see from that, the application in that case was made under both Section 35 and Section 98. That's what the official liquidator had relied on. And then if we go to 3188, Lord Cairns, at the top of the page, begins his judgment by effectively describing the jurisdiction which is conferred by Section 98. Lord Cairns, Lord Justice, after stating the facts of the case and reading the 35th section of the Companies Act 1862, and observing that in connection with it the 98th section must also be read continued. In my opinion, the reference in the 98th section to a rectification of the register cannot mean that the court, in winding up a company, is to rectify the register ex mero motu suo. It must mean that the court may exercise the judicial power conferred by the 35th section, having regard to who is the applicant and to all the circumstances of the case. So again, he sees Section 98 effectively as allowing for the jurisdiction conferred by Section 35 to be applied in a winding up and in connection with the settlement of the list of contributories. Now, in my submission, that relationship between those two rectification provisions is how the law has been understood. We've included in the bundle in volume 12 extracts from Buckley, which you'll find behind divider 64 of volume 12 at page 3408. And particularly over the page at 3409. Now, this edition of Buckley, as you can see from the top right-hand corner of the extract, is dealing with the Companies Act 1948. So we're now a few versions of the Companies Act onwards. In the 1948 Act, Section 35 had become Section 116, and Section 98 had become Section 2571. The commentary which you see at page 3409 is the commentary in relation to Section 116, in other words, what had been Section 35. And you can see halfway down what it says is section applies after winding up. The section applies after winding up, see Section 257. Again, consistent with the cases we'd looked at. And it takes the position that that does continue to apply after winding up, and the reason it does so is because of 257. And so far as 257 is concerned, the commentary on that you'll find behind divider 65 at page 3411. And again, about halfway down the page, rectification of the register. The reference here made to a rectification of the register is not intended to enable the court to rectify it ex mero motu suo, but means that the court may exercise the judicial power conferred by Section 116 having regard to who is the applicant and to all the circumstances of the case. And you can see from the footnote that's a reference to Sitchel's case, which we were looking at. After a winding up order has been made, the power of rectification given to the court by Section 116 is not cut down and reduced to a mere power of rectification in settlement of the list of contributories. It is open to a contributory or to the company after the order has been made and before the list of contributories has been settled to move rectification under this section and Section 116. But what's relevant about that is that it shows that the two forms of rectification power are understood as conferring essentially the same jurisdiction on the court. Section 35, as was, became Section 116 applied generally. Section 98, as was, what became Section 2571, made clear that that rectification jurisdiction continued to be available in winding up. But it's nowhere suggested, and as far as we can see never has been, that Section 2571 conferred any different or wider kind of rectification power to Section 116. Now, so far as rectification is concerned, in our submission, the exercise of the rectification jurisdiction depends on the applicant either having a right to be entered on the share register because he holds legal title to the relevant shares, or as having a right to be removed from the register because he no longer holds the legal title to the relevant shares. And for the purposes of those propositions, we rely on what the Privy Council decided in a case called Nylon against Royal Westminster Investments, although, as we'll see, what the Privy Council was largely doing in our submission was pulling together and summarising the existing law. But if I can just take you to that, that's in divider 11. So bundle 11 behind divider 46 at 2886. It's a decision of the Privy Council, and this was on appeal from the British Virgin Islands. It concerned the rectification provision in the British Virgin Islands Companies Act, but that is in basically the same terms as the equivalent English and Cayman provisions. And the particular issue in this case was whether the rectification jurisdiction could be used to determine a dispute between two parties about the entitlement to shares in the company. So, in other words, can it be used to determine a dispute between the transferor and the transferee as to who actually is the owner of the share? Privy Council held it could not, and that a person could only apply for rectification to have themselves added to the register if they already held legal title to the shares. And you can see that from the opinion of Lord Collins, which begins relevantly for these purposes at paragraph 36 on page 2898. And he says the parties very helpfully produced a schedule of the many reported cases on rectification of the share register going back to cases.
Where's this two?
Sorry, this is page 2898, paragraph 36, which is at the very bottom of the page.
Oh, right, yeah.
This is in the opinion of Lord Collins. He says the parties very helpfully produced a schedule of the many reported cases on rectification of the share register, going back to the cases on the Joint Stock Companies Act 1856. Paragraph 37, there are 2 points which emerge from the cases. The first is that from the earliest days of the legislation, courts have made it clear that the summary nature of the jurisdiction makes it an unsuitable vehicle if there is a substantial factual question in dispute. And then, paragraph 38, he refers to a decision of the English Court of Appeal in a case called Re-Hoycrest. He says appears to be alone in deciding it's sufficient for the applicant to have a prospective right against the company and not an immediate right to be entered on the register. There's no doubt that the legislation is primarily concerned with legal title. In London, Hamburg and Continental Exchange, Lord Cairns stated what might be thought to be obvious when he said the object of the section was to secure a red list or register which would show who were the shareholders entitled to the profits. That's the extract from London, Hamburg, which I showed you earlier. And then he goes on in paragraph 40, the great majority of the cases on the power of the court to order rectification involve a situation where a transfer has been executed but not registered, and the applicant seeks to be put on the register. 41, the next largest category is cases, many of which are old cases, concerning holders of partly paid shares seeking to avoid being contributories, where the applicant is already on the register but wishes to be removed, e.g. because the registration was affected as a result of misrepresentation. 42, the overwhelming majority of the cases turn on legal title. And then it goes on to deal with some possible outliers to that principle. But then at paragraph 48, he deals with the decision of the English Court of Appeal in a case called Re-Hoycrest. It says that stands alone in being an actual decision which turned on the question whether proceedings for rectification of a permissible vehicle for determining a dispute about beneficial ownership and whether they can be used not only by a person seeking registration of a share transfer, but also by a person claiming an order for transfer of shares. And then 51 is really the conclusion. In the view of the board, proceedings for rectification can only be brought where the applicant has a right to registration by virtue of a valid transfer of legal title, not merely a prospective claim against the company dependent on the conversion of an equitable right to a legal title by an order for specific performance of a contract. He's obviously dealing now with the category of case concerning someone who has to come on the register come off it. Now, in our submission, that reflects the conventional understanding of the rectification power. And that power doesn't, in our submission, confer a discretion on the court or anyone else to alter the shareholdings in a company. Rather, it's a jurisdiction which is available so as to ensure that the register of members, as a documentary record, correctly reflects the position as a matter of general law. It's concerned with ensuring that the share register reflects the position at law.
It's a question of accuracy.
Exactly. It's a question of accuracy. Now, that, in our submission, was undoubtedly the scope of the general rectification jurisdiction which appears appeared in section 35 of the 1862 Act and in section 116 of the 1948 Act and in what is now section 46 of the Cayman Companies Law. It's exactly the same provision. And we would further submit that the scope of the rectification jurisdiction, which was specifically available in winding up, in other words, the Section 98 jurisdiction, which was available in connection with the settlement of the list of contributories, was the same. It was the same jurisdiction. It certainly went no wider. What Section 98 and its successors were doing were making clear that that jurisdiction continued to apply in winding up. And the liquidator could do it in connection with settling the list of contributories. Now, before I go on to deal with the 2009 amendments, just a word on the present position in England. The present position in England is that the general rectification jurisdiction is contained in section 125 of the Companies Act 2006. It's at page 2387. I don't think we need to turn it up, but that is the modern incarnation.
Sorry, could you give me that page again?
Yes, it's 2387, volume 9, divider 12.
And it's section 125?
Section 125 of the 2006 Companies Act. And that effectively is the current version of section 35 of the 1862 Act. It hasn't actually changed very much. It's been slightly reordered, but the substance of it hasn't changed. Now, the jurisdiction dealing with rectification in winding up in connection with the settlement of the list of contributories is now to be found in section 148(1) of the Insolvency Act 1986. And that might just be worth turning up. It's in volume 9, behind divider 15, page 2395. This is the current version, if you like, of what was section 98. It deals with rectification as part of the settlement of the list in a winding up, and you can see subsection 1 is largely in the same terms. Now, you'll see there that the settlement of the list and the rectification is to be carried out by the court, which is what the 1862 Act had said. If you go on to section 160, which is at page 2400, behind divider 17, there's also provision in the Act for delegation of powers from the court to a liquidator. You'll see section 161B allows for delegation of the settlement of the list of contributories and rectifying the register of members where required.
I'm so sorry, which page are you on?
I'm on page 2400.
Thank you.
Within section 160
Yeah.
sub 1. And it may just, just for your note, there has been such a delegation, which is Rule 7.79, 7.91 of the 2016 insolvency rules. But it's interesting to note subsection 2 is that the liquidator is not allowed to rectify the register of members without special leave of the court. So the way we approach it here is to say that the delegation of both the settlement of the list of contributors and the rectification of the register of members is delegated to the liquidator, but in the case of rectification, he can't do that without special leave of the court. But there's no suggestion that rectification bears any different meaning in any of these sections. And plainly, in section 148, it bears the same meaning as it does in section.
Well, I'm a little perplexed by section 160, subsection 2. Why is the special leave of the court required if rectification is only a matter of ensuring that the register is accurate?
Well, because it's a matter for the court ultimately to adjudge what the legal title is and to ensure that the register is accurate. And then I suppose, I mean, ultimately, the register of members is obviously a critical document in winding up both.
But, I mean, without being pejorative, it's a technical exercise, isn't it, really?
It is in the sense you have to form a view on what the legal title is, and then it's a question of making sure
Accurate, yeah.
But I mean, maybe it's a part of the historical background that this has always been a power given to the court.
Mm-hmm.
The rules allow for delegation, but in this particular case, rectification register.
Yes, well, it does have important consequences, I suppose you would say.
Well, I mean, the key to it all is that citation from Lord Collins, which we saw in Nylon, where he cites from Enviroco and Farstat, where he says the register is conclusive at any moment in time as to who is or who is not a member of the company.
Yes. Exactly. And it's obviously, I mean, we're obviously concerned in this case with the question of the distribution of assets, but it's obviously also potentially very important, the question of who's liable to contribute, partly paid shares or anything like that. Assets to people, it may be a question of imposing liabilities. Well. But I show you that just so you can see the development through and the position we've got to in England. Obviously, what we're primarily concerned with for the purposes of this appeal is the position in the Cayman Islands. Now, prior to 2009, the provisions of Part 5 of the Cayman Companies Law, which deal with winding up, were almost a direct reproduction of the relevant provisions of the 1862 Companies Act. Now, I'll show you the citation for that in a moment. In around 2005, the process of updating the Cayman Companies legislation began. That might perhaps have been overdue by 2005. The Cayman Law Commission produced a report dated April 2006, which recommended that various changes be made. And the Commission also produced a draft bill which updated the existing Part 5 of the Companies Law. Now, the report itself you'll find in the Supplemental Authorities bundle, beginning at page 4. And you'll see it's entitled Review of the Corporate Insolvency Law and Recommendations to the Amendment of Part 5 of the Companies Law, April 2006. You can see from page 5 over the page who the members of the committee were. And then on page 7 there is an executive summary. See from the first bullet point, it said the existing law suffers from being unduly complex because it's derived from a combination of 19th century legislation. The Commission therefore recommends that the existing law and best practice be codified by rewriting Part 5 of the Companies Law. And then if you go on to page 9, paragraph 4.3, bottom of the page makes good the point I was just making, that Part 5 of the Companies Law is a direct reproduction of the English Companies Act 1862. Like the rest of the Companies Law, is not until now been the subject of any comprehensive review. And then there's then, just turning the pages, a discussion of various different aspects of the winding up of companies and the liquidation, which are considered. None of those are relevant for our purposes. And then on page 20, paragraph 18, you get the conclusion. Second sentence, the Commission recommends that the Companies Law be amended in the form of the enclosed draft bill. Final sentence, the rationale for each individual amendment is set out in a very detailed Memorandum of Objects and Reasons. Now, just pausing there, there's no mention at all in the Law Commission paper of conferring any substantive new power on a liquidator to rectify the share register of investment funds so as to override or vary proprietary rights of shareholders. And we do make the submission that if that had been the intention, that would inevitably have been something that the Law Reform Commission would have remarked at least.
Well, your submission is that that would represent a fundamental change to the power of the agency, be it the court or the liquidator, carrying out a rectification exercise.
Yes, huge
So
change.
one would expect it to feature prominently in the report.
Exactly, and that's...
that may be a reason for the slightly initially surprising omission from the report of any reference to section 112.
Yes, I mean, we'll come to the draft bill in a moment, but absolutely that's our submission. And when you look, I mean, it pays reading the report itself as a whole, because you can also look at the sort of matters it does refer to, and particularly when we come to the Memorandum of Objects and Reasons, it descends into a lot of detail about very technical points of company winding up. And against that background, not to refer to 112.2 if it had been intended to impose this if it had been intended to confer this very extensive, novel, far-reaching jurisdiction, is to say the least very surprising. And if we go over to the draft bill, you have that behind divider 2. This is, as you see from the title, the bill for the law to repeal.
Okay.
So this is page 21 of the Supplemental Authorities Bundle.
Thank you.
A bill for a law to repeal and replace Part 5 of the Companies Law, 2007 revision, in order to reform the law related to the winding up of companies. And then page 22, you have the introduction to the Memorandum of Objects and Reasons. And then page 23, about a third of the way down, it begins a section-by-section summary of the amendments, and it says the main provisions under Part 5 are as follows, and it goes through in quite a lot of detail on a section-by-section basis what is being amended. And what is very telling in our submission is when you get to page 28, paragraph 21, Section 111 provides for the stay of a winding up by the court. And then all it says about Section 112 is this. Section 112 deals with the settlement of list of contributories by the liquidator. It specifically refers to Section 112, doesn't mention at all very novel, far-reaching, substantive power which the appellant says was conferred on a liquidator of an investment fund. The idea that if the intention had been to confer such power, it wouldn't have been mentioned there. That submission untenable. Plainly, draftsmen thought that whatever they were doing, of sub 2 wasn't something that was worthy of comment in a very long document that deals with all of the amendments in a blow-by-blow account.
But they have in fact adopted the what is now Section 112, subsection 2, as part of their recommendation.
Oh, absolutely, yes. So it was.
And have you looked at the reports that are listed on page 22 in the supplemental bundle?
We have. No, well, the short answer is no, we haven't looked at them. We approached the Law Reform Commission to ask for copies of them, and they don't have them available in their archives, unfortunately. So having read that, it did strike us it would be interesting. And we've looked at those reports as well. But those aren't available to us.
But what about KPMG? Wouldn't they have had them? Since it stimulated this debate. And the Financial Services
Possibly.
Secretariat.
Possibly. I mean, I don't think we've gone as far as asking private individuals. Approached the Law Reform Commission, and they've told us they don't have them.
Well,
but in any case, I mean, I would say one could infer. I mean, if any of those papers had been saying, look, we think it's a good idea to confer this new substantive power on a liquidator, I mean, that would inevitably be picked up in the memorandum of objects and reasons, because the whole raison d'etre of that memorandum is to summarise exactly what the legislature is doing.
Except it's all headed main provisions of Part 5 as of the principal law, or as follows, so they weren't purporting to give a completely comprehensive summary. And at 2006, of course, the Madoff fund had not become gone into liquidation, so there may not have been any particular interest in it.
Well, I mean, I think what one would say, I mean, it's certainly right that the Madoff fraud hadn't happened.
But it happened, hadn't been discovered.
Yes, hadn't been discovered at this time, you're quite right. I mean, what you've got is a summary going on from 12 pages of a document, and I mean, it's dealing with some technical...
Well, I suppose you would say that if the Law Reform Commission had recommended this pretty fundamental change in the law, wouldn't have expected the cryptic reference you get in the draft bill to Section 112.
That's exactly right. I mean, effectively, it's not just cryptic in the sense that all it refers to Section 112.1, it doesn't.
Yeah.
And if the Law Reform Commission had been intending that, I mean, plainly that would have been something they'd considered appropriate.
And what's the... You mentioned the date of the report.
Yes. April 2006 was the date of the report, and that had the draft bill attached to it.
It falls through two holes then. It's not mentioned as part of the recommendations in the report, which the beginning of the memorandum says the bill is seeking to give effect to.
Yes.
And it's not picked up in the detail in this memorandum.
And for what it's worth, there is no mention of, in Hansard of any discussion at this point. Acted. Now, the amendments made by the 2007 law came into force on the 1st of March 2009. And if we can just look at how Section 112 had altered, the previous version, in Volume 9, Tab 11, 2384. And you'll see that subsection 1 is basically the same as section 98.1 of the 1862 Act. But what's important is the concept of rectify and rectification was already there. It wasn't something that was new and that was introduced in 2009. It was already there in the Act. And then, as you'll see, that required the court to settle the list of contributories and to rectify the register of members. And you can see then the amended version, which is at 2361, behind 5-6. And one can see how it's changed. Now, in our submission, the changes were in effect twofold. The first is that the settlement of the list of contributories was now to be carried out by the liquidator rather than by the court. That brought Cayman into line with the English position, albeit by a different route. We got the same result by way of a delegation, but they position simply by changing the person in the primary legislation who could carry out the settlement of the list. And the second change is that in the case of an investment fund in solvent liquidation, the rectification of the register could also be carried out by the liquidator. Now, we agree with the point my Lord Briggs made earlier in that there is arguably an omission in section 112. It doesn't deal with rectification of the register in winding up in the case of a non-investment fund. But in relation to that, the answer is that such rectification in that case would continue to be carried out by the court pursuant to section 46. But so far as the changes which were made are concerned, in our submission, the focus was on the identity of the person.
Isn't it worse than that? Because they haven't just not given that power to the liquidator, but they have not preserved the old text, which was always interpreted, at any rate in Buckley and in English cases, as extending the old Section 35 power into a liquidation context.
Yes.
So on one view, not even the court can do it.
Yes. I mean, I can see that argument, but I think my submission is the way the court...
One sort of says, well, they can't really amend that.
Yes, exactly. I mean, and the way one would have to approach that is to say, well, the intention must have been that Section 46 continues to apply. It doesn't apply winding up in relation to... But what we would say about this is that when you look at the changes which were made, they haven't changed the concept of rectification. That remains constant. It's the same concept which was there before, which had been there since 1862. That remains. They haven't introduced that as a new idea in 2009. What they've done is change the identity of the person who can carry out the exercises of settling the list of contributories and rectifying the register. Now, the appellant in his submissions tries to dismiss that explanation of the extent of the changes as mere procedural convenience, is the word he uses. And he seems to seek to imply that there must be something more to it than that. That can't be the explanation. Not so in our submission. First, it was a significant change with practical consequence for the way in which winding up is carried out. Here's a practical matter that a settlement of the list of but in any case, many legislative changes can no doubt accurately be characterised as being matters of procedure and inconvenience. Certainly ones that don't merit a mention in the Memorandum of Bill and Objects which precedes the law. But the key point we would make, and I'm going to come back to this, is the concept of rectification isn't new. And if the draftsman had been intending to introduce an entirely new jurisdiction, which confers these novel powers on the liquidator, why is it he used exactly the same term, which was already there, and which had well established the legal position?
It's clear, isn't it, that Rule 12.2 came later because they don't go in this report to question the rules. They recommend the establishment of a rules committee.
Exactly.
And presumably Rule 12.2 comes out of that. Is that right?
That's right, yes.
Do we have any knowledge of the background of that? Or?
No, I mean, what I know, and we can check this, is that you'll see the bill was dated, I think, September 2007, which went before the Cayman legislature. And then, as I understand it, the legislation came into force on the 1st of March 2009. And I believe that the rules came into force. So the inference was, I think, that they were prepared in the period between the presentation of the bill and the act. Then
Yeah.
We'll check for you the exact dates on which the rules
I mean, Rule 12.2 does suggest something which goes beyond one's normal concept of rectification.
Well, in my submission, not, because Rule 12.2 only applies where the NAVs aren't binding because of fraud or other default.
Just let's have a look at it again.
Yes.
What's the reference, please?
So the reference to the winding up rules, it's tab 9 of volume 9. 2366 it begins.
2367.
2367, absolutely. And it's Rule 2.1 that really bites on this point. And the critical thing about Rule 2.1 in our submission is it applies where the NAVs are not binding upon the company and its members by reason of fraud or default. We're looking at a position where, as a matter of general law, the NAVs are already not binding for some reason, whether it's fraud, misrepresentation, mistake. Some principles, matter of general law, mean the NAVs aren't binding. In those circumstances, the rule engages. And
It represents a perception that a non-binding NAV may lead to the wrong persons or being shown as shareholders, or to the amount of the shares owned by a person being wrong.
That's right, yes. So, it's useful in this concept, probably, the distinction between internal and external fraud, because in our submission, Rule 2.1 will engage on the case where the fund itself is fraudulent, and therefore fraud unravels everything. NAVs are not binding both in relation to subscription and redemptions, and you can restate the register, or try to do it, by reference to what were the true NAVs. That, of course, is a world where the reason the NAVs aren't binding is because of some existing legal reason.
Yes, but it doesn't tell you how the liquidator is required to exercise the power, and added to that, subparagraph 5 makes it clear that the liquidator may be able to depart from the legal rights if he finds it's impractical to rectify in accordance with the provisions of the rules. He may then decide on some cost-effective and fair and equitable allocation. So that's not adhering to legal rights.
Yes, firstly, sub-rule 5 was introduced later in 2010, but secondly, sub-rules 3 through to 5 concern the distribution methodology. In order to get into those rules, you have to go through the gateway of sub-rule 1 first of all. You don't get to the question of distribution methodology set out in rules 2 through to 5, unless you first got a position where you're within rule 2.1, because the NAVs are not binding upon the company that's meant for every fraud.
Yes, but your point was that once he's decided to, once that's triggered, he has to then apply the parties' legal rights to figure out what they were, given that there was no binding certificate. But when we get to subsection 5, and this is once subsection 1, subparagraph 1 has been triggered, he is then given the power to decide how to allocate, and it's not in accordance with rights.
Well, yes, and if it came to it, we would say there's a real question about sub-rule 5. This is introduced on delegated legislation on the rules making pound section 155. It was introduced later in 2010, so it wasn't part of the original 2009.
Well, that doesn't matter because we have to interpret the rules as a whole. Once it's been amended, you interpret the rule as amended, just as legislation.
We're interpreting the rule, but I suppose as a guide to the meaning of the legislation, if you're talking about interpreting them as a package, and looking at what was enacted at the same time, the rules and the legislation didn't contain this. But in answer to your point, in our submission, it's very difficult to see what the legal basis is. Saying that as a matter of the rules, the liquidator has a power simply to impose a distribution methodology as he thinks fit.
Well, it follows from your argument that you have to say that, and that you have to say that paragraph 2, if it does give a power to allocate other than in accordance with strict legal rights, is ultra vires section 155 of the Act.
Not paragraph 2, no. I mean, we'd only have to deal with subparagraph 5.
Well, that depends on what subparagraph 1 is permitting, because it doesn't actually specify a basis of allocation. It doesn't matter, actually, for this purpose of the argument, whether it's subparagraph 5 or 2, 1 and 5. But either way, you have to say that's outside the enacting power in the primary legislation.
No, I don't believe we do. I mean, with respect, I mean, so far as 2.1 is concerned, in our submission, that is the gateway into the power, which is the direction that is conferred by the rules. Rule 2 is giving a direction to the liquidator as to when he has to exercise a power, which is given by the Act. Now, that direction arises in circumstances set out in Rule 2.1, and most relevantly, it requires the NAVs not to be binding on the company and its members by reason of fraud and default. That is entirely consistent with our submission to the meaning of the rectification jurisdiction in 112.2.
Well, I suppose it partly depends on what is meant by the expression cost-effective and fair and equitable.
Well, it does.
But we'll all ponder that over lunchtime and we'll sit again at 2 o'clock.
Thank you.